Hello, my name is Jimmy Yang. Today I will talk about TCC Judgment 112 Shenpan 14, case on the recusal of judges in the retrial and appeal of criminal cases. High notes. Article 17, subparagraph 8 of the Code of Criminal Procedure, which required judges to recuse themselves if participated in a decision at the previous trial of the same case, is constitutional. The term previous trial should be interpreted as the decision at a previous trial of a lower court, and it does not include the situation where the judge had participated in a decision at a previous trial of the same instance that is the same level before being quashed. Within this parameter, therefore interpretation number 178 needs no supplementation. In situations where the retrial or extraordinary appeal judges have participated in the previous trial of the final decision of the same case, the Code of Criminal Procedure is unconstitutionally insufficient for lacking specific provision requiring the judges to recuse themselves. Article 2 of the Supreme Court's implementation standard on the allocation of civil and criminal appeal cases quashed twice previously, and Article 9, Paragraph 1, Subparagraph 1 and 2 of the Supreme Court's implementational standard on allocation of criminal cases, and the resolution of the 8th joint meeting of the presiding judges of the criminal panels of the Supreme Court of 1994, which stipulated that cases that have been quashed twice and those that concern major crimes should be assigned to the judge who previously quashed the case on the final appeal, are constitutional. These provisions are internal standards stipulated by the Supreme Court under the protection of judicial autonomy and do not violate the right to judicial remedy. Supreme Court Criminal Precedents 29 Shang 3276, which rule that the judge at the first and second instance who have participated in previous trial are allowed under Article 17, subparagraph 8 of the Criminal Code to hear the case as the retrial judges of the same level after a higher court quashed and remitted the case is constitutional, and the disputed precedent does not infringe on the defendant's interest in appeal under the right to judicial remedy. Background note. This case concerns the rules of recusal for judges in criminal procedure when it comes to retrials appeals against retried cases and extraordinary appeals. There are a total of the 52 petitioners in this case, 37 of whom are currently on death row. One of the petitioners was petitioning on behalf of the two brothers executed in 2014. During the petitioners' respective criminal trial, retrials, or appeals, they were all faced with a similar situation where the judges in the proceeding were the same as in their previous trial. Their situation can be classified into three main categories. A. Any of the retrial or extraordinary appeal judge had participated in trials of a previous instance. B. Any of the final appeal judge is the same as the judge who previously quashed the case for retrial. This happens when the case has been quashed twice or when it concerns a major crime. And C. Any of the retrial judge at the first or second instance has participated in a previous trial of the same instance before a higher court quashed and remitted the case. The petitioners filed for constitutional review respectively. They mainly argue that by allowing judges of the previous trial to participate in the cases in above-mentioned situation, the following provisions and decisions unconstitutionally violate the principle of lawful designation of judges, due process of law, and consequently infringe upon their rights to a fair and trial and judicial remedy. Article 17, subparagraph 8 of the Code of Criminal Procedure, hereinafter Code Provision 1. Article 2 of the Supreme Court's implementational standard on allocation of the civil and criminal appeal cases quashed twice previously. And 3. Article 9, Paragraph 1, Subparagraph 1 and 2 of the Supreme Court's implementational standard on allocation of criminal cases, hereinafter Standards Provision 2-1 and Standards Provision 2-2. Resolution on the 8th joint meeting of the presiding judges of criminal panels of the Supreme Court of 1994, hereinafter the Supreme Court Resolution 1994. And 5th, the Supreme Court Criminal Precedents 29, Shang 3276, hereinafter the Supreme Court Precedents 1940. For the same reason, the petitioners also called J1 interpretation number 178 to be supplemented. In addition, two of the petitioner lodged for constitutional review against their final criminal court decision. The petition for 52 petitioners were consolidated. The TCC held a public hearing and summoned related party for opinions on October 24, 2022. The briefing was attended by attorneys of three of the petitioners, representatives from the Supreme Court, and the Criminal Department of the Judicial Yuan. Summary of the judgment holding. The term where the judge had participated in the decision at the previous trial. The term where the judge had participated in the decision at a previous trial in Code Provision 1 should be construed, that is, should be interpreted as where the appellate judge of the case had participated in the decision of the same case at a previous trial of a lower level. That is, the term where the judge had participated in a decision at a previous trial. What is the meaning of previous trial in Code Provision 1? Shall be interpreted, shall be construed as where the appellate judge of the case had participated in the decision of the case at a previous trial of a lower level, and it does not include the situation where the judge had participated in the decision at a previous trial of the same level before being quashed. So long as the provision is construed, that is, interpreted as such, it does not violate the protection of the people's right to judicial remedy under Article 16 of the Constitution. J1 interpretation number 178 needs no supplementation or adjustment within this scope. Retrial or extraordinary appeal judges should recuse themselves if they had participated previously in the final decision of the case. Retrial or extraordinary appeal judges should recuse themselves if they had participated previously in the final decision of the case. The Code of Criminal Procedure lacks the above-mentioned recusal provision, thus unconstitutionally violates the protection of the right to judicial remedy under Article 16 of the Constitution. The competent authority should amend the code as appropriate within a 2-year grace period. Before the amendment, newly lodged cases and the cases underway should be tried per the requirements of this judgment. So, before the amendment, newly lodged cases and the cases underway should be tried according to the requirement of this judgment. Standard Provision 1 and 2-1 stipulates that when a criminal case was previously appealed and quashed twice by the Supreme Court, it shall be assigned to the last judge that quashed the case on the fourth and later appeals to the Supreme Court. The provision do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. Standards Provision 2-2 and the decision of the Supreme Court Resolution 1994 provides that quashed major criminal cases shall be assigned on the later appeal to the judge that quashed it. The provision and the resolution do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. The Supreme Court precedents 1940 ruled that the situation where the retrial judge at the second instance had participated in previous trial of the same level before a higher court quashed and remitted the case does not constitute a ground for recusal because the trial was of the same level, which is different from the situation where the judge of the previous trial joined the case on appeal. The precedent does not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. The petition of the petitioner number 1, petitioner number 4 to 52 are meritless and shall be dismissed. In terms of petitioner number 3's constitutional complaint, Supreme Court Criminal Order 111 Tai Kai 657 is unconstitutional. It shall be quashed with its matter remitted to the Supreme Court. Petitioner number 39, constitutional complaint toward the Supreme Court, criminal judgment 111, Tai Shang 2479 shall be dismissed. All of the petitioner's motion for preliminary injunction shall be dismissed. Thank you. Bye bye.